Lord's Lady, I apologize for this, but
not at all.
But we now have the decision in BA, which was referred in Begum and was referred yesterday. If you look at page 3 of the decision, paragraph 19, this may assist with some of the questions that were covering the court. So in his submissions, Mr. Clark, who represented the Home Secretary, submitted that concealment of the material facts would have had an impact on the decision to grant citizenship, and he relied on IV, and he said that that is the test. The Upper Tribunal applied that test, that is paragraph 42, paragraphs 41 and 42.
Sorry, hold on. 40.
This is page 8. The decision is in two parts.
Wait a minute. Oh, sorry, yes, I've got it. 40, which, tell me again?
41 and 42. This is page 8 of the authority. It's in two parts, the decision. The second part starts at page 10 onwards. So IV is the test that the Upper Tribunal applied.
Sorry, yes, but it's not setting down a principle of law for the purposes of Section 40. Dishonesty has to be established.
No,
it's just saying in the context of this appeal, the central question to be answered is whether the appellant was dishonest in his application. That's how it's phrased.
Yes.
But go on, sorry.
Just that that IV applies in deprivation cases. In my respectful submission is fairly well settled. I mean, I'm aware of at least five other decisions where I haven't printed everything, but at least 5 other decisions, deprivation cases, where IV was applied. Most occasions on the insistence of the Secretary of State that this is the test. Can I just highlight this on? Again, I understand the question, my Lord, that there isn't anything in this decision setting a principle of law as such, but in the authorities bundle, behind tab 46, you have the Secretary of State's deprivation and nullity of British citizenship guidance. This is chapter 55.
Yes.
And can I ask you respectfully to look at page 1131?
Yes.
This is paragraph 55.7.7.1 under the heading deliberate. The caseworker should be satisfied that there was an intention to deceive. An innocent error, a genuine omission should not lead to deprivation.
Mind you, that might get in, I entirely agree and understand, but that might get in on the second basis. Etc.
But that, in my submission, makes no difference to my case, because either it's the first stage or the second stage. If there isn't a decision by the tribunal as to whether there was dishonesty in the citizenship application, applying the IV standard, then that is an error. So if my learned friend would say that, intention, mens rea is simply irrelevant, then I suspect my learned friend will have to justify how that submission is consistent with what the Secretary of State is publicly saying about this provision.
Right, thank you.
Very grateful.
Yes.
Thank you, my lord, my lady. I will address the facts in some detail, because in part I will say that the facts make my submissions for me. And then I will deal briefly with each of the grounds of appeal. Before I do that, could I just deal with where we are procedurally?
Yes.
We submit that if this appeal is dismissed, then the Begum issue doesn't arise. I accept that if the appeal is not dismissed, it will be going back, it needs to be remitted, and if that is the case, we certainly don't object to public law arguments being run in the tribunals below. And that, I think, is all
On
I
a
need to
rehearing.
say.
Yes. Thank you.
So could I then turn to the facts, and beginning in the core bundle, just to start with the decision letter,
Yes.
which is at core bundle 113, but the core of the reasoning is really at paragraphs 19 to 21. So paragraph 19 sets out that evidently you were married in March 2001 and have never been formally divorced.
Sorry, starting at 19.
Paragraph 19, yes.
Yes.
So the second sentence, evidently you were married.
Oh, yes, I see. Yes.
And then the divorce deed which you supplied in support of your permanent residence application implied that you divorced your Pakistan wife and that your relationship had come to a permanent end. However, it's now been stated that this was only an intention to divorce. And I'm starting with the decision letter, but when I go back through the facts, it's very clear why the Secretary of State was suspicious, to say the least, about what was going on. And then, just to point out that the decision letter decides the deprivation point on two bases. What paragraph 20 is saying is that if we'd known the truth, you wouldn't have got your EEA residence card. And so you wouldn't have met the requirements for naturalisation. And that's a point we took in our amended respondent's notice.
Where does it say that?
In paragraph 20. So it goes through, first of all, it sets out Regulation 8 of the 2000 regulations, then it points out what the guidance says, and then it says, had the Home Office, just by the second hole punch, had the Home Office known that the Pakistani divorce deed document was not a genuine document, then your relationship would have been investigated before granting you further leave to remain. It's actually a residence card, but you were only issued your residency in the UK as it was believed you were, not you was, in a genuine relationship with your sponsor and your previous marriage had permanently broken down. It's therefore apparent that you practised deception and withheld the material fact that you were still married, and I'll show the court why it's material. Given that you've not, this is the 4 lines from the bottom, given that you've not divorced your wife and you returned to Pakistan and conceived a child, this confirms that your marriage had not broken down permanently. If the caseworker had been aware that you were still married to your Pakistani wife and conceived a child, you would not have been granted permanent EEA residence, which was a prerequisite to the grant of citizenship, and I'll show the court the legal provisions that underpin that part of the decision. And then the second part, paragraph 21, is the sort of good character point that we saw taken in the decision letter in the other case.
What about Ms. Malik's point that you could, in fact, have a continuing relationship with your wife but still satisfy the EEA requirements by having another durable relationship?
You can't, and I'll explain why.
Okay, thank you.
So I'll take that in stages. So now I will go through chronologically, beginning first of all with the application for an EEA residence card that Mr. Malik showed the court. He's taken the court to the directive and the regulations. Could I just flesh that out a little bit in case the court is curious? I don't need to spend long on it.
Which is this? This is
this
in
green
the green.
bundle.
Thank you.
So Mr. Malik is right. Under EU law, there are two discrete species of family member rights. There are direct family member rights, which are automatic, and then there is what is called the extended family member right, and that is a very limited right, as I'll show the court in a moment. But effectively, that there are various stages to being able to benefit from that right, and one of the first hurdles is to show that you actually meet the definition of extended family member. So if you don't get through the gateway of showing that you're a durable partner, you can't be an extended family member. But even if you get through that gateway, there's then an extensive consideration of your circumstances.
Yes.
There's a lot of case law on this right, including in this court, but none which need trouble the court. It's well established that it's not enough just to be a durable partner, you have to get the card. Because until you've got the card, you're not treated as a family member. And can I just show the regulations again and just be absolutely clear about what's needed to
Yes.
get a right of permanent residence? So
is there anything else we need to look at in the regulations? You've taken it
yes,
through?
with in the regulations now, I'm sorry, yes.
Yeah.
So tab 3, starting with Reg 7, page 23. So Reg 7.1 deals with what I just called direct family members, which is the automatically qualifying family members.
Yes.
And then Regulation 7.3 says that a person who is an extended family member, so they meet the definition of extended family member, and has been issued with one of those various documents, shall be treated as the family member of the relevant EEA national. So A, you fulfil the definition, B, you've been issued with the document by the Secretary of State, and then finally, or as long as he continues to satisfy the conditions in Regulation 8. So it's not good enough to have been a durable partner once and to have the card. You have to continue being a durable partner, otherwise you're not a family member for the purpose of these regulations. And then Regulation 8.5 sets what I described earlier as the gateway condition. A person satisfies the condition in this paragraph, this is page 25, if the person is the partner of an EEA national and can prove to the decision maker that he's in a durable relationship. So you go along to the Secretary of State, you say, I'm a durable partner, this is how I prove I'm a durable partner. The Secretary of State looks at whether you're a durable partner. If she doesn't consider that you are, that's the end of it. If she does consider that you are, or some other category of extended family member, she considers her discretion. I should say, in the old days, of course, not anymore, but that's how it works. And then to get permanent residence, page 27, Regulation 15.1b, a family member...
Sorry, it's 15, yes.
So essentially permanent right of residence is a better right, and you get it after 5 years of complying with relevant conditions. And it does then allow you to apply for naturalisation, which is what happens here. So Regulation 15.1b, that's the relevant provision that applies. It says, the following person shall acquire the right to reside permanently. A family member of an EEA national who's not himself an EEA national but has resided in the UK with the EEA national in accordance with these regulations, that's important, for a continuous period of 5 years. But in accordance with these regulations means you have to comply with 8.4, which was what I showed the court earlier. I'm sorry, 7, you have to comply with 7.3 and 8.5. In other words, you've got to continue meeting the definition of extended family member, as well as having a card and as well as living with the EEA national. So, just to be clear, when this appellant wanted to get permanent residence, he had to show that throughout a 5-year period, he had met the requirement to be an extended family member by being a durable partner, as well as his sponsor exercising treaty rights for those 5 years, as well as having lived with her and other things. But it's important to understand it's not just getting the card and then residing in the UK. That's not enough. And I don't think, in fairness to Mr. Malik, that that's what he was suggesting, but I just want to be clear. And then...
But as you pointed out, getting the card is a necessary feature, a necessary requirement of the commencement of the chain.
Absolutely, and there's case law, there's several cases in this court which confirm that. And then, can I just invite the court to turn to tab 5 and page 78, where I've sidelined the relevant passage. It just explains, as a matter of EU law.
Sorry, which page?
Page 78.
Sorry, thank you.
Tab 5. This is a judgment of the ECJ in a case called Rahman, and this was basically the case that tells everybody what Article 3.2 of the directive is all about. And Mr. Malik's already shown the court that provision. So perhaps I could just invite the court to read paragraphs 21 to 25.
Yes.
Now, paragraph 24 refers to dependents. That's because a different category of extended family member is somebody who's dependent. But the important point for my purposes is that each member state has a wide discretion as regards the selection of the factors to be taken into account. The host member state must ensure that its legislation contains criteria which are consistent with the normal meaning of the word facilitate and of the words relating to dependence, or whatever the limb is of the provision in the directive, and which do not deprive that provision of its effectiveness. So, in my submission, it's a classic situation where what you have is a reference in the regulations to the need to prove to the Secretary of State that you are a durable partner, and then the Secretary of State fleshing out in guidance what she expects to see to be satisfied.
Yes.
Now, in my submission, turning back to the facts, there's a very simple reason why the appellant submitted the divorce deed. Because the Secretary of State's guidance made clear, as a matter of domestic law and practice, that she needed to see evidence that the relationship had permanently broken down. So any immigration lawyer who knew their stuff, which one would hope, would know, or certainly know where to look, what the Secretary of State's guidance said about showing that you're a durable partner. And that, in my submission, is the most likely reason why a divorce deed was submitted in 2009. And I'll show the court the guidance
Well,
now.
doesn't the Upper Tribunal judge deal with why, and I've forgotten again whether it's a he or she, I think it is, isn't it? Concluded that, considered that it had been submitted. I thought that was...
He does, and I think your lordship took my learned friend to it in the course of his submissions, but I can't now put my finger on where it was.
Well, it's 63.
Yes, and look at 6, yes.
The
Yes,
produced for reasons other than those given by the defendant and his wife, would have declared in his application for entry clearance a student who was married a need to draw a line under that relationship if he was to stand any realistic chance of securing a resident card.
Yes.
It was for that reason I find the divorce deed came into existence. So that's the Upper Tribunal judge's finding as to the purpose for which the divorce deed was submitted.
So what I can do to save time here is just to refer to paragraph 39 of our skeleton argument, where we set out all the bits of guidance that were relevant, and then tell the court where they are in the bundle. But I don't think there's any dispute about the accuracy of what is in paragraph 39 of our skeleton. And it absolutely explains why the Upper Tribunal judge said what he did. So paragraph 39(1), we refer to the EEA caseworker guidance entitled Chapter 2, and that's in tab 49 of the authorities bundle. I'm happy to take the court to this guidance if that would be useful. Equally, I'm happy simply to give the court the references.
Do you want to go through this one? Why would just take us through paragraph 39 for the moment.
So
just tell us where it is.
39(1) is in tab 49 of the authorities bundle.
Which we saw earlier anyway.
I think it was what's in 39(4), but I may be wrong.
We looked at 51.
51, yes. So 39(1) is in tab 49. The relevant bit of the immigration rules is in tab 45.
And what page?
It's the front page. As you can note, actually got the page numbers written down. It's the beginning of that tab. 1121.
Thank you.
Yes.
And the page references in the 40. There's a sideline passage on tab 49. There's a sideline passage, and that should be read with the passage directly above it, which is page 1200.
Sorry, we're on to 3 now, are we?
I'm sorry, I jumped back to 1. It was confusing of me. So paragraph 39(1) is AB 49, page 1200. 39(2) is AB 45.
Sorry, hold on. 1200. I think we're now looking at it.
Evidence of a durable relationship, yeah.
Yes, page 1200. And so that the EEA guidance then uses what is in the immigration rules. So that's why we then end up in the immigration rules. And
So
then
this is 1121.
yes, 1121 is the immigration rule.
And it's the sideline bit, is it?
Yes, and the bit.
Which says he's not remained in breach of the immigration law.
Sorry, the sideline is in the wrong place. It's
D2.
Any previous marriage or civil partnership was permanently broken down.
Thank you. Yeah, it only dropped a couple of spaces, but it was enough to be misleading. Yeah, thank you.
For some reason, my bundle printed out without any sideline, and I thought, having added it myself, I put it in the wrong place. 39(3), Annex Z to the EEA caseworker guidance is tab 50. Sidelines, page 1207.
So is this the same caseworker guidance that we're looking at under 1?
No, this is what the first guidance is EEA guidance, and then there's then Annex Z to EEA caseworker guidance.
Which sounds very similar.
It does, yes, but it's a separate piece of guidance.
Anyway, it's divider 50.
Divider 50, sidelines, 1207.
Thank you.
And then the EEA caseworker guidance, which Mr. Malik did take the court to, is at 1212.
So are these separate documents?
They are. They're separate pieces of guidance,
Right, okay.
but they all say the same thing.
But they're all to the, yes, they're all to the same effect.
Yes.
That you have to, as appropriate it says, produce evidence that any previous marriage or civil partnership is no longer subsisting.
Exactly. Now, a point to make on tab 51, which Mr. Malik did take the court to.
Page.
1212.
Thank you.
Yes.
Under 1.3 partner, Mr. Malik is confusing two separate things. There is the requirement to have been in a durable relationship with the EEA sponsor. That's got nothing to do with any other relationship which you might happen to be in. So the parties have been living together in a relationship akin to marriage, which has subsisted for 2 years or more. That's the requirement that bites on the EU sponsor.
Yes.
It's got nothing to do with testing whether the previous relationship
I think
is...
Mr. Malik was trying to turn that round.
Yes, it can't...
And say that and this is where I thought it was becoming speculative, that might have caused somebody to answer a question in a certain way, the appellant, because he hadn't been living with his wife for the previous 2 years.
No, and
that's
clearly wrong. And when one looks at the form, it's clearly wrong, but it's not what the guidance is saying. And then the sideline bit on 1212, again, any previous marriage has broken down. So somebody in...
So wherever you look, you have got to demonstrate that any previous marriage has broken down.
Exactly.
And as the Upper Tribunal judge pointed out, in the application for entry, the appellant would have said that he was married, and so, as he put it, he needed to draw a line under that relationship if he was to stand any realistic chance of securing a residence card. And you're just showing us all these materials to substantiate or to help us understand why the Upper Tribunal judge said that.
Exactly. And to show that unquestionably, this, whatever one wants to call it, this fraud or concealment or had a material bearing on the grant of the applications and therefore a material bearing on the grant of citizenship.
Because the grant, having a residence card was a necessary step on the way, and if the previous relationship, marriage, had not ended, was still subsisting, then that would not have been granted.
Precisely. So, just a couple of points on the application for permanent residence.
Can I just ask before you leave that bit?
Yes.
Ms. Marrick also said, well, in fact, the regulations don't require you to have, you just need the durable relationship, and that's enough. Are you saying that if you still have an existing marriage which hasn't broken down, then that's the bar for the reasons you've given?
Yes, so I'd make 2 points about that. The first is that, as I've shown in Rahman, the court says it's a matter for the domestic state, and the Secretary of State's entitled to flesh out what she considers is required to meet that requirement, which she has done. The second point is this, that it may well be, although it's not to my knowledge been done, but it may well be that somebody might want to challenge that and say, well, no, I can be in 2 marriages at once, thank you very much, and I'll qualify under the rule. But that's not the question here. The point here is that the applicant, or that the appellant, approached matters on the basis of the Secretary of State's guidance, and she was deceived. The right approach is clearly not to provide a divorce deed when the parties aren't divorced, but to tell the truth, and if the Secretary of State rejects the application because you're married to somebody else, challenge that in the tribunal. So So this case is not about the rights and wrongs of what the Secretary of State asked for. It's about whether the condition precedent in section 43 was met, and it was, because the Secretary of State's guidance made clear that she expected any previous relationships were broken down.
Well, yes, I mean, if the Secretary of State was going to apply the guidance set out what you've shown us. And so I suppose you might say someone could challenge the guidance and say that's not necessary or not an appropriate feature to include.
Exactly.
Yeah.
Just then in the permanent residence application, Mr. Malik rightly took the court to page 87 of the supplementary bundle, but could I just start with page 86, which is question 11.17.
It's right that the form for to become an extended family member and acquire a residence card, it doesn't actually, there's nothing additional that we haven't been shown. There isn't actually any question in that form itself. Are you married? Has your marriage come to an end? There's nothing in the...
No.
Okay.
I mean, what would usually happen is that, and as I understand it happened in this case, is that the person doesn't just submit the form like in other immigration applications. What they do is they send a letter with various documents attached, and sometimes they make representations at the same time. And in this case, what happened was there was a letter which included the divorce deed.
Yes.
But
and we haven't got that.
No, you haven't.
No. Okay.
No.
So the application wasn't, as it were, sent in by itself.
No,
No.
it wasn't. No, and it's certainly a finding of fact that the First Tier and the Upper Tribunal made that the divorce deed went in
Right.
with the 2008 and 2009 application.
So did they have the letter?
The tribunal?
Yeah.
I don't think so. But that perhaps they did, perhaps somebody had it. I've certainly seen it. But certainly both make a finding. It was common ground, I think, that the divorce deed had been submitted.
Yes, there's no challenge to that. But obviously, if your case is their material misrepresentation is made, then having them set out in writing is sometimes quite helpful.
Yes.
Anyway, we haven't got the letter.
No, and certainly we know the divorce deed was submitted, but what happens at the permanent residence stage is more clear. So beginning with question 11.17 on page 86, I'm just drawing the court's attention to this because if you've answered yes, have you included the children in this application? It's page 86 of the supplementary bundle.
Yes.
No. Children living with their mother in Pakistan as agreed between their mother and the applicant. Now, there's a direct reference to the children there. It's clearly in my submission a distancing from the children and the mother, and that the reason I show the court that bit is because it looks particularly odd when one looks at the complete about turn when the appellant wants instead to get leave for his wife. So here he's trying to get permanent residence.
Yes.
Then question 11.22.
Yes.
I don't understand the submission here. It says, do you or your sponsor currently have another spouse or civil partner, or an unmarried or same-sex partner with whom you or they are in a durable relationship? So the durable relationship bit belongs to the words unmarried or same-sex partner. The appellant did have another spouse, depending on which version of events. So that was untrue. And then 11.24 is clearly relationship lasted 7.5 years. So in other words, he's representing that the relationship is over.
Yes, I see.
And then for completeness, there is a question about good character on this form. Page 103, 17.8.
There isn't any express reference to 11.22 in the Upper Tribunal judge's decision, but the Upper Tribunal judge found that there was material concealment and/or whatever he said in respect of both the application for the residence card and this application.
Yes, and we say he was entitled to reach that conclusion simply by provision of the divorce deed, but this form makes matters worse for the appellant.
And was this form in front? Must have been in front
Yes.
of the Upper Tribunal.
Yes, it was.
Yeah.
Yes, this is from the Secretary of State bundle.
Right. Sorry, you were taking us to another.
Yes, so question 17.8, just to note, is a question about good character. And then
Sorry, 17.8.
8.
Right.
And then
Have you ever engaged in any other activities which might indicate you may not be considered to be a person of good character? And the answer is no.
And then, importantly, page 107, which goes to section 11, which is the section we were looking at just now,
Yes.
expressly asks for evidence that any previous marriage or civil partnership has legally ended, e.g. divorce certificate. That's page 107 of the supplementary bundle, between the two hole punches.
Yes.
And then, at least in this, and then a series of declarations on page 108. And then appears the divorce deed again.
Sorry, say it again.
There's a series of declarations.
Oh, I see.
And then
Yes. And then we get the divorce.
Then
deed.
there's the divorce deed again.
Yes.
So that's 108. Sorry, where?
108.
Divorce deed
109.
itself is 109.
The divorce deed is 109, but it's
So it's the evidence provided in answer to section 1122 as added
yes,
pursuant to the notes on page 107 is the divorce deed
Yes.
at 109.
I'm
Yes.
saying if it wasn't material to the success of the application that the previous relationship had broken down, the Secretary of State wouldn't be asking a question about it, nor would she be asking for evidence.
And so there's a declaration that the information is complete and true to the best of the applicant's knowledge.
There is.
Or where it's an offence to make a statement or representation which I know to be false and is not briefly true, to seek to obtain a document certifying permanent residence by means which include deception.
Exactly. There are many parts of that declaration which give a warning.
Yeah.
To tell the truth. So that's the permanent residence application, and that is successful. It's not successful initially, but it goes off to a tribunal on the question of whether the DEA sponsor was a worker.
Yes.
So that's that part of the history, and then the citizenship application, just so that the court has them, the legal requirements are referred to briefly at paragraph 64 of the First Tier's decision, Upper Tribunal's decision, tab 36, and we looked at this yesterday or the day before,
Sorry, hold on. Tab 36.
of the authority bundle.
Yes.
So it's a different bit to show the court.
Sorry, you said it was referred to where in the Upper Tribunal, judges?
Paragraph 64, the judge refers to the appellant having met the requirements for citizenship by getting the 2 cards.
I see. Sorry. Yes.
And this is why. So it's section 6 that we looked at yesterday, which says the Secretary of, if on an application for naturalisation the Secretary of State is satisfied that the applicant fulfils the requirements, he may, if he thinks fit, grant him a certificate. And then on page 1009,
Yes.
that's paragraph 1 of Schedule 1, and that
Yes.
says somebody has to be of good character. We looked at that yesterday, but also that the requirements specified in subparagraph 2 or subparagraph 3 are met. And the relevant requirement here is on page 1013.
Sorry, 1013. Yes.
And that sets out the various requirements to do with being in the United Kingdom, not being in breach of the immigration laws.
But it
And
doesn't
so
say
on.
he needed to have a card.
No, but that gets him through. Because once he's got a card, he's not here in breach of the immigration laws. I think that's,
If the card's obtained on a false premise, then he would be in breach of immigration law.
well, yes, there's an interesting question
Oh.
about whether it needs to be revoked or not.
I see.
But in any event, he's got himself through the requirements by having the card.
Yeah.
Yes, and the Secretary of State did sometimes revoke these cards when she found out
Yeah.
that the requirements weren't met anymore. Although the regulations essentially, your ladyship's quite right, because the regulations essentially say it's not just good enough to have the card, you've actually got to meet the requirements of the card as well. Now,
But no, what she didn't ask, are you still in the durable relationship?
for citizenship,
Hmm.
no, that doesn't matter. Mr. Malik's right about this, that once you've got the permanent residence card, you're here lawfully.
Yeah.
And so you can then not be in the durable relationship anymore. So you've got to be in it for 5 years. And then once you've done the 5 years and had the card and been in the durable relationship, you get your permanent
But you
residence
pointed
card.
to the regulations,
Yes.
which were then in force, which showed us you still needed to be in the relationship, and it seemed the relationship had come to an end before the 5 years.
No, it hadn't. It
It
came
hadn't.
to an end after the 5 years.
Right,
Yes,
okay.
and just the chapter and verse on that, the first tier decision on the appeal against the Secretary of State's refusal of the permanent residence card is in the supplementary bundle.
Yep.
In fact, I may have put my tab in the wrong place. I'll give the court the reference. It's at page 179 of the supplementary bundle. First tier Judge Hetherington
179.
179,
Thank you.
and it's paragraph 7.7, which says they lived together as a couple in December 2006, but the 5-year qualification period was completed in 2015.
Yes.
Now, the relevant version of Guide AN and Form AN, which the tribunal saw yesterday, and I accept the form is not the filled out version, but the blank version, which was in place at the time, are at tabs 53 and 54, and I don't need to ask the court to turn those up, but that's where they are.
Were the blank forms in front of the Upper Tribunal?
I don't know, although, as I recall, the judge does refer to
He
I-
refers. Sorry, go on.
I was just going to say, I'd rather infer from what he said that he hadn't even seen the blank forms. But I'm not sure whether that's right.
He may no. He in that case he may not have done. We've certainly retrieved the actual form since and disclosed it, but we haven't put it in front of this court because it wasn't in front of the Upper
No.
Tribunal. But in any event, those were the forms. And then just a supplementary point to make is that in the actual deprivation letter, the decision is made by reference to an older version of the guidance, and I didn't pick that up until last night. However, the actual version of the guidance in place that the decision was made was materially the same, and I've shown Mr. Malik that version, but I just wanted to make that point.
Your duty of candour complied with.
Yes. Yes, just to be clear, and we did check it, so there we are. So, so up until that point, just recapping, the appellant's in a relationship with his sponsor, and as far as everyone is aware, he's had a divorce, his wife and his children are somewhere else, and it's all over. So, unsurprisingly then, what happens when he makes an application, once he's got his citizenship in his pocket, things rather change. And what happens is that he makes an application for his wife to come to the UK. And now a very different picture is presented.
Wife and children, or just wife?
wife and children. So could I ask the court to turn to page 119 first of all, the supplementary bundle, which is the application. Where you see a K at the top, and the court may recall this from yesterday, the decision
Annex to the
annexes,
decision matter.
exactly. So this is Annex K, and then what happens is the Secretary of State prepares a bundle with all of these annexes. So if it's got an annex number, it means it's been in front of the First Tier Tribunal. So the bit of this application that I'd ask the court to look at is on 1, 2, 3. At the top in the right-hand column, about 7 lines down, the Secretary of State started to get suspicious.
Where are we?
So CID, it says, show sponsor is married to EEA national, not declared relationship. So what happens is the Secretary of State gets this application, and I'll show the court the statutory declaration that the appellant makes to support it. And the Secretary of State gets this application and says, well, hold on a minute, our records show that you're not married to an EEA national, that's wrong, but that he's in this durable relationship.
So this is an internal document?
This is an internal document, yes. This is the Secretary of State's records of the application.
So it's not like the GCID notes we were looking at yesterday, it's a different kind of document.
I'm never sure of the difference, but this is an internal. I don't quite know why it's a different format, but this is an internal
file note.
It may be that it's internal file note.
Can I just confirm, CID stands for Case Information Database?
It does, yes.
And GCID means Government Case Information Database.
I'm looking at Mr. Malik, see if he knows. I've always...
Well, you two would know best.
Yes, we would... General.
Yeah.
Yes, I
General,
thought, we think
yeah.
it may be General
Case
Information Database.
Thank you. Sorry to interrupt.
So the statutory declaration is at SB Supplementary Bundle 129. Paragraph 1. I wish to sponsor my wife, namely Mrs. Farhat Sabui. I also wish to sponsor my 4 children as my dependents. That's paragraph 2. Paragraph 4. My wife and children are currently residing, and I want them to join me in the UK.
And he confirms there his biological children, closing DNA report, paragraph 3.
Yes. And then over the page, paragraph 14, I confirm that my wife and I got married on 18th of March 2001. I lived with my wife for 5 years and then I moved to the UK. I continuously remained in regular contact with my family via WhatsApp and telephone calls. I regularly visit my family. I visited them on the following dates. I've enclosed a marriage certificate, wedding photographs, family photographs, WhatsApp chat history and call records. And the court will look in vain for any reference here to the EEA sponsor, to the divorcee, to any of that. There's simply no reference to it. What's now being presented very clearly is a marriage that has been ongoing.
And what did the WhatsApp and call history records show? Did they show any break at all?
I haven't seen those. What we do have, there's over at the page at Annex M is what's enclosed, which is a marriage certificate.
And then you go to Annex D because on page 123.
The annexes are in a bit of an odd order. I've got a note that Annex N is at page 125 of the core bundle. But that's Annex N is something different. It's what happens, unsurprisingly, the Secretary of State's letter, having seen this and comparing it to what she's been told before. So unsurprisingly, having got that statutory declaration from the appellant, which is not, it's actually declared and before a solicitor. the Secretary of State writes and says, okay, considering depriving you of your nationality. And what then comes back from the appellant is at page 133 of the supplementary bundle. And plainly at this point he's got some explaining to do. So the cover letter is at page 133. Please find enclosed our response to your letter, together with representations and supporting evidence. So first of all is the representations. Page 135 says that the Secretary of State, at 3b, the Secretary of State has been constantly informed of the marriage throughout the respondent's applications for residence and nationality, but then says, indeed, the respondent has provided the Secretary of State with a copy of an affidavit indicating that she'd separated from him and wanted the divorce, which is a bit confusing. And then we get the reference to the witness statement, which follows. The consistent evidence provided in two witness statements of the respondent and his wife were that they are separated and not in a subsisting relationship at all relevant times from 2016 till 2017. Whilst they had contact in that period because of their children, and indeed had conceived a child during that time, it cannot be said that that constituted a subsisting relationship. And then we get witness statements, again confirmed by statements of truth from both the appellant and his wife. The appellant's witness statement is at SB 141. And this is his explanation of that inconsistency. Paragraph 9. Could I just invite the court to read it? So now he's saying it wasn't actually a divorce. If that's right, that information was, of course, never given to the Home Office.
Is that a reference back to the document that's on page 109 of the supplementary bundle?
It is.
Because that pretty clearly says...
It does.
Now the executant, with her free will, without any compulsion or coercion, do hereby pronounces triple divorce by uttering the words from her mouth and thereby separates, blah, 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 from his marital ties permanently.
Exactly.
This divorce is irrevocable.
Yes.
You'll have full rights to enter into the second marriage after expiration of 3 months statutory period.
Yes.
To which the executant will not have any objection.
Exactly. So that was his attempt to explain away the issues, and there are various other things. I won't take up time with the court now, but the court obviously picked up from the Upper Tribunal's decision that the explanation for the conception of the child is that there was a one-night stand. And his wife, in this statement, which is at page 144 of the supplementary bundle, at this point, although she changes it later, gives a similar account. Page 144, paragraph 6, 7 and 8. Could I invite the court to read those, please? So she's saying as well, oh no, it actually wasn't a divorce after all. And what then, before I come on to the Upper Tribunal decision, what the First Tier picks up on is that there is hopeless inconsistency on this issue about whether or not there was a divorce. So we've just seen that when he is responding to the Secretary of State's decision, minded to deprive letter, he says it wasn't an actual divorce, and his wife says the same. But by the time the witness statements go into the First Tier Tribunal, the evidence has changed again. So turning up the appellant's witness statement in the First Tier Tribunal, which is at page 149, he now says, paragraph 10, page 150, I received a divorce deed from her where she stated that she'd divorced me and she didn't want to be with me anymore. At the time I accepted the divorce and I was relieved that she had divorced me. Paragraph 15, he says, he's advised that it was a valid divorce.
Sorry, 15.
15, 1, 5.
Okay, yes.
And then, somewhat surprisingly, in the light of all of this, he declares at paragraph 42 that he's always been open, honest and truthful with the Home Office. So the account at this point has now become, oh, I did think it was a divorce, and then when we sparked our relationship in 2017, we found out that it wasn't a valid divorce. That's now the story.
Sorry, did you go on to a different
It's
document?
but still, I'm summarising what's in paragraph 36.
Sorry, yes.
So now the story's being advanced. In 2017, it's the first time that he becomes aware that effectively he wrongly considered himself a divorcee, because it's only then that he finds out that the divorce hadn't actually taken place.
Didn't need to re-register the marriage.
Yes, it's all okay. It was all a mistake. And his wife also gives a witness statement to the First Tier Tribunal, which appears at 170, and she also goes back on what she put in her witness statement to the Secretary of State at the time of contesting the reminded to deprive letter. And she says, no, that's all the fault of translation. So paragraph 4 of her statement on page 170, She then says, paragraphs 4 and 5, the previous witness statement she gave back to the Secretary of State wasn't accurate because there were translation problems. And she now says, the same as the appellant, that she did consider herself divorced between 2008 and 2017, and that appears from paragraph 21 to paragraph 28 of her witness statement. So and just for the court to know, the First Tier Tribunal was set aside, but on grounds that it didn't properly apply issues around the burden of proof. But it makes pretty conclusive findings about that inconsistency that I've just shown the court. So it takes a very dim view of the evidence, the First Tier Tribunal. Its decision is at page 79. And what the First Tier says, for example, at paragraph 17, is there's a notable difference in both of the wife's accounts about the divorce issue, and the account in both of her statements is similar, but for whether she knew that the document was a finalised divorce document or not.
Yes.
So that then is the background picture that the Upper Tribunal has when it comes to do its remaking decision. And just for the court to note, we don't need to turn it up, but the error of law decision which precedes it is at page 58 of the core bundle. So by the time that the Upper Tribunal comes to its remaking decision, and obviously all of my submissions are without prejudice to my submission that it shouldn't have been conducting this exercise for itself, but the question which it is asking itself is, was this citizenship obtained by fraud, concealment of a material fact, or false representation? It's asking itself a factual question, and in part what I described yesterday as an evaluative assessment of the materiality. But in any event, it's a simple case where a court or tribunal has to make a finding of fact. Now, what we say in our skeleton, in our overarching response, is that precisely as my Lord Justice Dingemans said in argument, it's very difficult to appeal against findings, and Mr. Malik has made a valiant attempt, but none of his grounds come close to undermining the Upper Tribunal's decision. Now, I have set out in the skeleton argument at paragraph 28 the principles which apply, A, when a court or tribunal is making factual findings, and B, when an appeal court is being asked to overturn them.
Paragraph 28.
Paragraph 28.
Thank you.
Now, we haven't, I don't understand any of that to be contentious, but I thought it was useful to draw it together. The only authority that we included in the bundle, because it's an immigration case, is Hussein, which is about circumstantial evidence. So the court has that at tab 26, the authority fund, but all of this is not surprising. It's established beyond any doubt that when a court or tribunal is making findings of fact, it's entitled to look at the evidence as a whole, it's entitled to take into account inherent probabilities, it's entitled to take into account implausibilities, and come to a conclusion of fact. So those, we say, are the guiding principles. And then we say the starting point is that the Upper Tribunal reached the factual conclusion to which it was clearly entitled to come. And I will just take a moment in the Upper Tribunal's decision, if I may, because I say that Mr. Malik is engaging in impermissible island hopping in the language of the case law. That's Fage and Shabani. And when one looks at the decision as a whole, there's clearly no material error of law in it. In fact, it's difficult to see, not that I need to go this far, how the judge could have reached any other conclusion given the gross inconsistencies in the evidence before him. So at paragraph 40, just to note that he rightly directs himself that it's for the respondent to establish that it's more probable than not that the citizenship was obtained by means of fraud. And he actually directs himself in accordance with Balajagari, that the tribunal has to bear in mind the serious nature of the allegation, the serious consequences which follow. So that's spot on.
So you accept there's no difference between you, that whether it's actually the Secretary of State satisfied of the concealment and then the discretion, there has to be dishonesty.
No, I don't, and I'll come on to that when I deal with ground 3. What I say is one has to be very careful because there are so many possible factual matrices, and my fundamental submission is on ground 3 is one shouldn't gloss the statutory language. But I certainly have to accept what my Lord Justice Moylan said, which it's also difficult to see how one could innocently conceal a material fact. But my legal submission is that the language of section 40 stands for itself, and whether on the facts of any particular case that requirement is met needs to be dealt with separately, and that one doesn't need to read the word dishonesty into it. And I submit that Ivy and Jenting it's not necessary. One doesn't need to get into that. It's a simple question of asking those statutory questions, and it's an interesting question about, well, what about on particular facts? Could there be concealment? What about an innocent representation? But in my submission, that's very far from the facts of this case. But I accept it's difficult to see how the statutory provisions could be met if somebody does something innocently. And it's clearly a provision which is directed at fraud, and I accept that one would construe those statutory provisions, the limbs of section 43 of the piece. But I wouldn't want to go further than that on the facts of cases that aren't before this court. So there's discussion about the burden of proof, but paragraph 46, then, what the judge says, and again, this is absolutely spot on, bottom of paragraph 46, what is required is a holistic evaluation of all the evidence to decide whether the respondent has discharged the legal burden of proving the allegations I've summarised above. And then what happens, at paragraph 47, I should also say that the judge, again, consequences of a finding of dishonesty are serious. The standard of proof remains the civil standard, and so on. So the judge is well aware of the features that Mr. Malik highlighted. Now, what the judge then does is precisely what he's entitled to do, which is to look at the evidence and to pull out inconsistencies and implausibilities. And there are three main strands that he pulls out. So the first strand, A, is at paragraphs 48 to 52. And that's a strand of reasoning relating to inconsistencies in the evidence between the appellant, his brother, and his brother-in-law about when the appellant's wife left their former family home. Now, there's no attack on that strand of his reasoning, so he's already identified an inconsistency there. He then goes on to say, and this is strand B of the reasoning, paragraphs 53 to 55, that there are inconsistencies and implausibilities about the evidence in relation to the reason why the wife left the family home. And he concludes at paragraph 55, without getting into the nitty-gritty of the facts, that there's a significant difference between a woman leaving a matrimonial home with 2 young children and leaving the matrimonial home with 2 young children and a baby. He doesn't accept that, and there's also a significant difference between her leaving the family home because she was disillusioned by his decision to go to the UK, and her deciding to leave the family home because he was having an affair. Given the significance of those events to both sides of the family, and given the centrality of the periods of the matter, I find these inconsistencies damaging to the credibility of the appellant's account. Again, absolutely spot on. Judges doing what the county court judges do up and down the country day in, day out, which is look at the whole of the evidence, look at inconsistencies, look at implausibilities, and decide on the balance of probabilities where the truth lies. So that's already 2 strands of his reasoning. We've got nothing to do with the bit that Mr. Malik focuses on. And then he comes on to the next bit, which is he simply does not accept what's being said about, well, yeah, I know we weren't having a relationship, we just happened to conceive a child during a one-night stand. That's the reasoning that's at paragraph 56 to paragraph 59. So we're already on the 3rd strand of the reasoning, and the bit that Mr. Malik challenges by his ground 1 is a small bit of this 3rd strand of reasoning. Now, the judge, of course, has heard the evidence, and this is what the cases say. The appeal court has to bear in mind that the judge has heard the evidence. This judge at paragraph 59 is clearly not impressed, because he says, having considered, and what he considers it, I'm sorry, I should have started here. What he considers is at paragraph 58, he's considering the evidence that there was a one-night stand in context. The context, he's already said, is that he doesn't find that these are credible witnesses. And then he says the first part of the context is provided by the claimed deterioration of the relationship between the appellant and his wife, and the reasons given for that deterioration. She's said to have learned less than 3 years previously that he'd been having an affair with another woman. She was so disgusted and upset that she pronounced talaq and believed herself to be divorced. So what he's saying is, this isn't really very plausible, that you say this is all disgusting, and then you just happen to have a one-night stand. And that is a factual conclusion which a judge is clearly entitled to reach. Doesn't find what he's being told credible or plausible. Then the judge says the second part of the context is geographical and is taken from her appeal statement where she states that the distance is only 200 yards. So in other words, that the evidence was, well, we ended up having a one-night stand because I couldn't go home. And the judge is saying, well, I don't really believe that because the distance was only 200 yards. And it's only then that he adds in, and actually, the third part of the context is societal. And it may be taken from the country guidance, and he makes some comments about society in Pakistan. Now, I'll deal with that specifically in ground one, and I won't need to take long on it. But the point here is, this is a small strand of the reasoning. This judge is clearly very unimpressed with the evidence, and rightly so in their submissions.
So in other parts, in other words, it's the third part of the context of the third strand of the reasoning.
Exactly. Yeah. And then at paragraph 59, again, absolutely correctly, he says, when considered against his backdrop, I found the account of the events in early 2011 to be wholly unconvincing. Having listened to the appellant give evidence about the reason that his wife was said to have initiated a one-night stand, 3 or so years after she believed herself to have divorced him, I found it wholly incredible. That's the conclusion he's reached after hearing the evidence. I don't accept she would have initiated any sort of sexual contact with the appellant if she'd been scorned in the manner suggested, thereby exposing herself to potential difficulties at the hands of her own family or the authorities. Now that's really all of that's bringing together various reasons why he found that account incredible. And indeed, taking a step back, one might say, even if one weren't looking at societal considerations in Pakistan, even if all of this were purely domestic, one might have made the same comment. A judge would have been perfectly entitled to say, as this judge did, I don't accept the evidence, that you've told me this, you've also told me these other things that I don't accept, and I don't accept as a matter of fact that this was a one-night stand. So those are the strands of the reasoning. Paragraph 60 draws the strands together, and then paragraph 61 says, therefore the respondent has discharged the burden. And then he goes on to deal with various arguments, and he goes on to find that there has been material fraud. Now, we say it's not surprising that when granting permission, it was Lord Justice Nugent, I think, said this appeal is likely to face considerable difficulties, but, and he...
I think it might have been Lord Justice Newey.
Yes, I'm grateful.
I think it was, yes.
Yes, it's not
Anyway,
surprising that he said that in my submission, because it does. So, with that in mind then, can I just now deal briefly with the grounds of appeal, because I hope that my position's become clear from our overarching response. So, starting with ground one, this is the country guidance point. I've shown that this is a small part of the reasoning. What the judge is saying is, I don't find this story credible, and I don't find it plausible. And part of the reason I don't find it plausible is because of societal norms in Pakistan, and I'll come on to the authorities in a moment. Now, even if he got something wrong in that bit of his reasoning, which is absolutely not accepted, it would not be a material error, because it's quite clear what this judge thinks of the evidence, and rightly so in my submission. So that's the first point. The second point is that Mr. Malik says, well, it's country guidance. It's easy to, this court will often see cases about country guidance. That's maybe, but this isn't an asylum claim. This is a case about a finding of fact in relation to whether somebody had obtained their citizenship by fraud. And more specifically, it's an issue about the credibility of evidence that somebody had pronounced a divorce and then decided and then gone ahead and had a one-night stand. So one has to put it in its proper context. And then looking specifically at what he says in the third part of his reasoning, in the third strand of his reasoning, one has to remember this is an expert immigration judge. He's a full-time immigration judge. He hears these cases every day. All he does is pick out certain features of the evidence in the country guidance cases when he's reaching his factual conclusion and say, yeah, that also seems a bit of an odd story given societal norms in Pakistan. That's all he's doing. It's not country guidance misdirection or anything like that. He quite rightly points to some of the evidence in those cases and says this is odd.
So the error of law, or there might be an arguable error of law, if there were a relevant country guidance decision and the Upper Tribunal had not followed it without explaining why they hadn't followed it.
Yes.
That you say that's not the position here. He simply referred to background material in the country guidance decision without any error of law.
Yes. And one might say even if he had done that in this case, it still wouldn't be a material error.
Yeah.
Because when one looks at his factual conclusions as a whole.
I mean, my point really is that, from my recollection, the error of law as is normally argued in relation to a country guidance decision is, what's argued is either the FTT or the Upper Tribunal have failed to follow a material country guidance decision and haven't explained why not.
Yes.
And that's just not this case at all.
Not this case. It's a completely different context. My point about it's not an asylum case. It's simply the judge saying from his experience of an immigration judge and picking things out from the country guidance cases about societal norms in Pakistan. So it's different.
And what about Mr. Malik's point that, well, you would expect it to get into the headnote if women in rural areas were treated as chattels, because then women in rural areas wouldn't get returned, and therefore, inferentially, the country guidance tribunal hadn't accepted this bit of evidence.
Well, the head note's quite short for a start, but the head note's very focused and it's specifically directed to the issue which the country guidance is considering. So,
which is normally an issue that arises on the facts of the individual appeal or appeals that are in front of the Upper Tribunal and which prompt the country guidance decision.
Exactly. So if Mr. Malik can say, oh, that's a very serious finding to say women are treated as chattels, well it may be, but that's if that isn't directly relevant or simply a feature of the evidence which leads the tribunal to its ultimate conclusions on country guidance, it won't be in the head note.
And does that apply to the second and third bits, which are gossip and the illegality of sexual intercourse outside of marriage?
Yes, so just to briefly turn up those authorities. Now, taking a step back, whatever one says about attacking bits of this and bits of that in these authorities, it's very difficult to dispute in my submission that there are serious issues in Pakistan in relation to the treatment of women and societal attitudes. I don't think that could be disputed from reading some of the evidence. That the position of women is not the same as the position of women in this country. So, just to turn up the authorities specifically, the first one in time is KA, and that's at tab 3. Tab 3 of the authorities.
Sorry, I thought you said 4.
Oh, sorry, tab 3.
Thank you.
The head, what it's called is KA and others domestic violence risk on return. So this is country guidance in the asylum context. It's not a case like this, which is just making a finding of fact. And then paragraph 3, all that it says, this is a case about the Protection of Women Act, as we'll see. But what it says is it's a legislative measure undertaken to improve the situation of women in Pakistan in the past decade, and therefore it's had a significant effect on the operation of Pakistan criminal law as it affects women accused of adultery. What that means is it's led to the release of imprisoned women, and most sexual offences now have to be dealt with in a different way. Husbands can't register a first information report. Offences of adultery have been made bailable. But then it adds, and this would have been enough, the judge could have simply referred to this. However, Pakistan remains a heavily patriarchal society. And then adds, and levels of domestic violence continue to be high. So the context of the appellant's wife and her inconsistent stories is that she declared a divorce, which she did or didn't believe to be true, and had a one-night stand. But again, I mean, that's in the head note, that it's a patriarchal society. And then we see what this case was about. Paragraph 1, the appellant claimed asylum, about halfway down paragraph 1, on 29th of August 2006, avowing that she had a well-founded fear of persecution on the grounds that she'd be pursued by her abusive husband, that she would be detained and prosecuted as a result of false adultery and attempted murder charges he had filed against her, and that she'd be ill-treated in prison. And what then happens, paragraph 4, is there's a case management review, and Judge Gleeson decides that this case would be suitable for possible country guidance on the effect of the Act and related issues. That's paragraph 4. So all I would point to in this decision is paragraphs 72 and 73. It describes evidence given by Dr. Shah that sexual intercourse is illegal in Pakistan except between a husband and wife. And then the reference to adultery is separate. Adultery was treated as a separate offence. And the PWA did not restore it. So there's two different issues as I read that. Sexual intercourse is illegal, and then separately adultery. And the PWA hasn't... a lot of the discussion is about adultery. But this isn't about adultery, it's about illegal sexual intercourse.
But if the intercourse is illegal because it's not with your husband or wife, then isn't that adultery?
Not if both, I suppose, if both parties are unmarried. I thought adultery would be... I don't know anyway, I'm speculating on Pakistan law, but I read those as being two separate things, because it says adultery was treated as a separate offence, but perhaps both are adultery in any event. But my simple point is, there's a clear basis for the judge saying sexual intercourse is illegal in Pakistan except between a husband and wife, and I pointed out paragraph 188 of the decision where the tribunal says the evidence on Pakistan law was weighty. It doesn't criticise. What it criticises is their evidence on society, but that's evidence on law. So nothing wrong in my submission in the judge saying, I note that's an additional factor which makes this account unlikely. Now, it's all very well to get into the ins and outs of the legal niceties, but what the judge is doing, and again, in the same way any county court would do, is looking at the practical realities for this woman. And all the judge is doing is saying, I don't find this account plausible for that and many other reasons. So that's that case. And then SM, which is at 14, this is a case specifically about ostracism of a mother with an illegitimate child in Pakistan. See paragraph 11, page 425, tab 14. There are, from about paragraph 47 onwards, which is country background reports and evidence, so it's not any old thing, it's actually properly weighty sources. So page 432, there's the Secretary of State's country of origin information. One can see by the top hole punch that women face patriarchal attitudes and deep-rooted stereotypes, so that's perfectly respectable source. There's paragraph 51, the US State Department report to Pakistan, which is what says women are treated as chattels and subject to discrimination. And one can go through all of these passages up until about paragraph 58 and highlight numerous instances of societal attitudes towards women in Pakistan which make the account of events unlikely, so which the judge was entitled to find. So that, for example, page 45, just between the hole punches, divorced women often left with no means of support as their families ostracised them. Paragraph 52 reiterates that. Again, Immigration and Refugee Board of Canada. A woman could divorce her husband, top of page 436, but social pressures made it difficult. Now, of course, we know here the judge was faced with this story that the wife had decided off her own back she was going to declare divorce, and that's not something he found credible. We get the reference to rural women being treated as chattels, and on it goes.
Can I just ask you about Miss Malek's point that, okay, fine, if you're right that the head notes don't bind and that the absence of findings don't matter, but in any event this is the wrong region?
Well, my instructions are that there are separate country guidance for Pakistan and for India, and I specifically checked this for Kashmir. Kashmir is covered by the Pakistan country guidance. Now, I accept that if there is a specific piece of evidence which refers to a specific region, I accept that's more difficult. But overall, my instructions are that guidance relating to Pakistan will also catch Kashmir. And certainly there's nothing to suggest that there's a stark difference between the norms described here and Kashmir for any reason. And one would have thought that Mr. Malek would have told us if there were. Seems somewhat unlikely. But in any event, we say the more general country guidance would cover Kashmir.
Thank you.
So, essentially, drawing all of that together, we say there are clearly serious issues about the treatment of women. The judge was entitled to draw features from the country guidance cases. He isn't making an asylum decision, so it's not the same issue as my lady said. He was entitled, as part of his factual conclusions, to make the remarks he did. But if he did go wrong, there was no material error, because one need only look at the rest of his decision. If one simply excised that part of the decision, it's absolutely plain that it would be the same. And indeed, the judge could have gone further. He could have made points about the evidence that the First Tier made, which was the significant change in accounts about whether there'd been a divorce or not. So that's the answer to ground one. The answer to ground two I can take very briefly, because I think I've dealt with it as I was going through the facts. The point in our submission is whether the citizenship was obtained by fraud, and I've made the point that the right course of events, if you think there's something wrong with the Secretary of State's requirements, is to tell the truth and give the Secretary of State the opportunity to know the truth so that she can make the right decision. But the point here is the Secretary of State's guidance was clear, and therefore the Upper Tribunal was entitled to conclude that the Secretary of State was materially misled, and that the position is that if the appellant had told the truth, his application wouldn't have been granted, and then he wouldn't have been able to get citizenship in any event. Now, as to the 2009 application, it won't be a surprise that my submission will reflect some of the questions that came from the bench during Mr Malik's submissions, which is, if the divorce deed wasn't relevant, why provided? It was provided for the reasons that the Upper Tribunal gave, which was to support the application. And in any event, it was clearly provided, and the same assertions were made at the permanent residence stage. So even if one forgot about the 2009 application, there's still material deception. Now, could I just draw attention to a passage in a decision of the Supreme Court on the tort of deceit? And the reason I do that is because I say not so much that clearly this isn't a case about the tort of deceit, but there's a comment which I say would apply equally here. It's a public policy type consideration, and I just invite it's essentially to respond to submissions which rely on what might or might not have happened if the truth had been told. Could I just invite the court to turn up tab 18 and read paragraphs 37 to 39.
'38 to '39.
37 to 39. So although this is a case about a fraudulent personal injury claim, but I submit that the comments that are made in the cases that discussed at paragraph 37 to 39 are equally applicable in the current context. So it's about, essentially, the court shouldn't subject the victim to what-if inquiries which the representor was not prepared to risk at the time. And based on the Upper Tribunal's findings, this appellant wasn't, he put in the divorce deed. So that's ground 2, and then ground 3. Could I start just by, because one in my submission it's quite simple. Section 40 sets out the statutory language. Ivy, which I'm going to invite the court to turn up at tab 20, certainly doesn't help this appellant. So one has to ask why the point is being raised. Now, Ivy is an interesting case about the Gosh test. The Gosh test on dishonesty, which we might all have studied when we did criminal law. But the fundamental point in Ivy is that there are serious problems about the Gosh test. So, could I just invite the court to read? No, in fact, that's unnecessary. Could I just read page 578, paragraph 58, the reason for Ivy is this. The principal objection to the second leg of the Gosh test is that unless the defendant's standards conform to what society in general expects, the less likely he's to be held criminally responsible for his behaviour. And the Supreme Court, paragraph 57, sets out a whole series of problems about the Gosh test, but that's the biggest one. So the Gosh test isn't in favour of fraudsters, it's the other way around. It's basically saying the test is too lax because it allows somebody who's got very bad standards to say I wasn't dishonest, because I think it's fine, a Robin Hood type character. That's all that Ivy's really about. So one has to question what relevance it could have in this case, where I can stop the sentence there. It doesn't assist this appellant, is my first answer to ground 3. But could I just make several points? The first is that one shouldn't impermissibly gloss the statutory language, but in any event, the Upper Tribunal makes repeated references to dishonesty. And it can't be suggested, for the reason I've just given, that something in Ivy helps the appellant. So, in my submission, for that reason alone, the ground falls away. But
I think Mr. Malik, sorry to interrupt, Miss. I think I've been calling you the wrong thing. You're Miss Smart.
It is. But
yes. No, I of all people shouldn't mispronounce other people's surnames. So you're essentially saying the Upper Tribunal referred several times to dishonesty. Mr. Malik's submission was they didn't direct themselves that the behaviour needed to be dishonest. But you say, well, if you read the decision, you can't believe that's what they were doing. Is that the point?
yes, and so the point falls away. And I don't. My primary submission is one has to apply the statutory language. But if it's right that there has to be dishonesty, the Upper Tribunal found that there was dishonesty, and anyone reading the Upper Tribunal's decision who said, oh, but he didn't think he was dishonest, would be quite difficult to take seriously my submission. Clearly he is finding dishonesty. The judge even uses the word. So
Mr. Malik suggested, I think, that there were a number of authorities which we don't have in this field which support the submission that dishonesty is a necessary separate element.
yes, and I will always defer to Mr. Malik's experience of case law in the immigration field, absolutely. And I think I have a vague recollection of the cases he's talking about, and I understand from having spoken to Mr. Malik that there are particular immigration provisions which use the same language as in section 40. The case we looked at, Geary, was different, as I recall yesterday, because it's paragraph 322. But my submission to this court is, for present purposes and for the purposes of this case, one need only look at the statutory language, and to the extent that there is a requirement for dishonesty, this appellant satisfies it, and the court doesn't need to go any further than that. And certainly if there's any suggestion that there's some particular special thing in Ivy that needs to be applied that would help this appellant, certainly not clear to me what it is, given what Ivy's actually about. So we come back to, in my submission, this. What was there? Was the tribunal entitled to conclude that section 43 was met? And despite having been looking at it for days on end, I still can't quote it without looking at it. Was the registration on naturalisation obtained by means of fraud, false representation, or concealment of a material fact?
So the statutory language suggests that the draftsman thought those three things were or might be different from each other.
Yes.
So would you submit that that's the right way to look
Yes,
at it?
and yes, that they're three separate limbs. I mean, to the extent necessary, I'd submit he meets all of them. He puts in a divorce deed. We still, the version of events has changed many times, but he puts in a divorce deed to show that a relationship has ended when it hasn't, so the Upper Tribunal finds. Well, that, it seems to me, is fraud. It's also a false representation, and it's also concealment of material fact, because if one looks at that stark difference between the permanent residence application on the one hand and all the information that's provided in the application on the other, one is saying my relationship has ended, the other one is saying it's still going on. And both of them are missing a large chunk of story. So, to the extent necessary, I'd say that the Upper Tribunal could have found that all the limbs were met, but in specific reference to Mr. Malik's ground 3, he certainly, to the extent that it's necessary that there be dishonesty, he finds that there is.
Well, speaking for myself, if there are authorities directly on the meaning of the expression fraud, false representation or concealment of a material fact, I think it would be helpful if they were provided.
Yes, and I'd have to look to mathematics.
Well, not a host of them, but if there are one or two authorities that directly address the meaning of that expression, could you?
Yes.
Sorry? But yes,
Yeah.
the higher the level of authority, the better.
No, yes, I will liaise with Mr. Malik and we'll do that as soon as we
Please,
can.
thank you.
So, wrapping up then, I say that the judge was entitled to conclude that the registration or naturalisation was obtained by means of fraud or false representation or concealment of a material fact of all three, because for two reasons. The first is the reason in my amended respondent's notice, which is that he wouldn't have met the requirements for naturalisation had he not put in his divorce deed. And the second is the fundamental reason in the Upper Tribunal's decision, which is that he presented himself as a person of good character. Just have a moment to check my note. Yes, and just finally, the one thing I would say is that questions about that there are discrete issues in my submission about Ivy specifically and what it does to the test for dishonesty, and quite separately issues about whether innocent misrepresentations and so on count for the purposes of section 40. But to the extent that the second issue is an issue in principle, it certainly doesn't arise in this case for the reasons I've just been submitting. Could I turn my back for a moment? Oh, I'm so sorry, Lord Justice Dingemans.
Well, what are you going to say about your Begum point?
My point on Begum is that this court doesn't need to decide it if it dismisses the appeal as I invite it to, because, and I think this is my Lord or Justice Dingemans' point about be careful what you wish for, because for this appellant, the evidence, the more times he gives his evidence, the worse it gets for him.
But the same actually also applies with the Secretary of State's principled submissions on the approach to Lord Reed, which would be look at decision letters, and we all know sometimes they're not drafted as well as they might be. Well, that's fine. But you then have evidence which makes the position abundantly clear, and what we all pretend that evidence has nothing to do with the matter, go back, find a public law error, quash the decision, send it back for an inevitable further refusal.
Yes, and
I mean, that doesn't seem to be the best use of resources when we all know that there are substantial numbers of these applications outstanding.
although one might say if one looks at the facts of this case, it would rather show the Begum approach working well, because if I went through that evidence carefully. What the Secretary of State had was a permanent residence application with a divorce deed on the one hand, a signed statutory declaration saying effectively you're within a family all along, and then 2 witness statements which come up with a very strange story, to put it politely. And at that point, in my submission, the Secretary of State would have been clearly entitled to say this is fraud, and in my submission at the court would have had ample evidence for the same reason. What happens for the appellant is he then gives more evidence and he makes things worse. But if one had stopped at that point, in fact one might say that in this case it's been a rather unfortunate use of resources.
Can I just ask one further question on the Begum point?
Yes.
Because obviously we've got to decide whether to decide it in this appeal or the next one.
Yes.
In Chimi, which you I think say is the right approach, Mr. Justice Doug pointed out that obviously when you have Article 8 there will be findings of fact to be made.
Yes.
Now obviously depriving anyone of citizenship is at least going to engage Article 8.
Yes.
Which means that you are going to have evidence given in any event.
Yes, in those cases.
And then what do you do with the evidence? Suppose it contrary to this case, or what you say is this case, where you say the appellant didn't help himself. suppose the appellant comes up with evidence like the German doctor example we discussed yesterday. I mean, the court was then to shut its eyes to that?
Well, no, but one would then hope in an example as he had cut as that, the Secretary of State would say, well, I'm revoking the deprivation order, or that the tribunal may say, well, clearly there is no fraud here, and therefore I'm allowing the appeal on Article 8 grounds.
But can Article 8 be used to circumvent the Begum approach? Just assume for a moment you're right, and the substantive issue, i.e., was citizenship obtained by one of those three methods? Can Article 8 be used to undermine the Begum approach in relation to that issue?
Well, one issue I'm sure Mr. Malik and I will agree on, that in the immigration context there are a series of cases, and Balajagari is one of them, and there's a case called Arsan, but all in this court, which talk about circumstances in which a dishonesty type allegation can be challenged by way of Article 8 appeal. And I don't want to even attempt to summarise Balajagari, but that Balajagari and Arsan are cases where there's a judicial review, and there is at the same time an appeal or the right of an appeal. So in Balajagari, what the Court of Appeal says, and I'm looking at this man, he will correct me if I'm wrong, I'm sure, but in
He's got an indulgent expression on his face.
I'm sure he looks at me like that. Most of my submissions, I don't know, that when Article 8 is engaged, then the court can decide the dishonesty issue for itself, and we can certainly provide Balajagari. It may indeed be one of the authorities which we provide in any event, but that's what happens.
So I'm not sure that's what Lord Reid thought in Begum. I mean, that issue probably wasn't ventilated, but yeah. Okay.
And it might be a good point just to draw attention to a passage in KV.
Yeah.
At paragraph 18, there's just a reference in KV at the bottom of page 552, tab 19. That when a state deprives a person of his nationality because of acts of deception, legally established, that deprivation cannot be considered to be an arbitrary act. And it's certainly right that the Secretary of State will certainly fight Article 8 cases on a proportionality type balance, but that there may well be a different issue if there's a clear question of fact. And my Lord Justice Dingemans' example, which is, well, this person has now produced a certificate, and although...
But that rather blows a hole in the sort of... as I understood it, there was an attempt to put clear water between what you've described as the Begum approach and the approach in which the FTT makes findings of fact. But from what I understand you're saying, if there's an Article 8 point in the case, that's potentially a way of undermining the clear-cut distinction for which you were arguing yesterday.
Well, and that's the reason why I took the court to passage in Begum, which says the approach will be different on the ECHR.
Yes, I'm not sure that that's what Lord Reid had in mind. But anyway, I absolutely see the point you're making.
But it's certainly it's accepted in principle by the Secretary of State that and this is in any context, where there is an ECHR issue, the tribunal decides that issue.
No, I understand
but
that.
There would have to be, Article 8 would have to be engaged.
Yeah. Because
plainly deprivation has, there's case law on Article 8 in the deprivation context, and I think Chimmy considers it. There's a case called ISAJ as well, which I was in with Mr. Palmer.
Yeah.
And it's difficult because it's a short period of limbo, for example, but certainly...
Because Article 8 might not be engaged in a deprivation case because the person might be outside the UK and have no family in the UK, in which case there's nothing for Article 8 to... All right, well that's an interesting point. But the other question I'd like to ask, please, is to what extent did the appellant put the test in issue in the Upper Tribunal. In other words, as I read the Upper Tribunal decision, the appellant was saying you shouldn't apply the Begum approach, you should apply you should decide this all on the facts. So did he, because I think Mr Malik was submitting that he had a fallback argument, which was,
Yes.
if you apply Begum, I should also win.
So, yes, so the first thing I should say out of fairness to Mr Malik is in the first tier, although that was pre-Begum, that this is at page 111 of the core bundle, that could be construed as a public law argument because it's an argument that the condition precedent wasn't satisfied and it relies on the approach to durable partners. So that's at the grounds of appeal, not Mr Malik's, but Mr Malik's side's grounds of appeal. The relevant ground is at page 109 to 111.
Seem to be missing a page. So my page.
Yeah, 110 is blank.
Yes, it's then the page after.
Who starts?
So it starts at paragraph
and then it goes
5.
over to page 111. And then there is written argument in the Upper Tribunal. I'm just checking to see if it's in the court papers.
Is that just simply an error of law argument? We can't see the whole of it. But anyway, all right. So that's the.
I was certainly prepared to accept that it was or could be a public law argument.
All right.
And then I'm just looking for the skeleton argument in the Upper Tribunal. Is it not? There's a First Tier Tribunal skeleton argument in the bundle. I had certainly read, but I'm sorry that I can't put my hands on it, something from the appellant in the Upper Tribunal which said, but if Begum applies, it's wrong for public law reasons. Now, it certainly doesn't raise all the grounds which are raised in Mr Malik's supplementary skeleton argument, whatever I saw, which I will find. But we would submit that what is now, if the appeal is to be remitted, that would then, to the extent that there are procedural skirmishes about amendment and so on, that they would be a matter for the remitted appeal.
Certainly, I suppose the one important thing to look at is the application for permission to appeal from the First Tier Tribunal to the Upper Tribunal.
We do have that.
And that's at tab 10. And there's a skeleton argument attached to that.
Yes. That's dated 22nd of March 2020.
So that precedes Begum. So
yes, that precedes.
as a matter of timing, it can't raise the Begum issue. So
although I should say there is authority of the Upper Tribunal that there has always been the ability to bring public law challenges.
right.
That's a case called Walil. It is in the bundles WALILE, and that does say you can't now raise public law challenges. But the reason I don't object to Mr Malik doing that on the middle is because I think enough has been done below to trail the arguments, as it were.
Yeah.
They not in detail or the way that they're now argued, but it's and paragraph 29 of the Upper Tribunal's decision. I just looking for.
Yeah, so paragraph 929 recites the argument. So there was. It looks as though there was certainly oral argument before the Upper Tribunal that there was a public law error. There was another skeleton in
Yes.
Mr. Malik's statement.
Yes.
All right. So there was whether or not there was permission granted to make a public law argument. One was raised, it seems. And where does the Upper Tribunal specifically deal with the public law argument?
It doesn't.
That's what I was wondering.
What it says, it doesn't deal with it, and I agree with Ms. Malik. What it says is I don't need to deal with that. It's paragraph 39. It's quite clear to me that the condition precedent question must be resolved against the appellant even on the conventional KV approach. Now, I might say, wrapped up into that is rejection of a public law approach.
Yes.
But in fairness to Mr. Malik, the reasoning, there's no reasoning.
But I suppose if you just look at the material that was before the decision maker and the reasoning in the decision letter, I mean, all of that's been referred to at some length. Effectively, what the Upper Tribunal is saying, that this argument's got no legs.
Yes, I have to say we certainly would say that any public law challenge would be exceptionally weak, and I would submit that it was unarguable, but that's not the threshold test. But given the facts, given the history, and the Secretary of State's decision is clear in its reasoning, given the material in front of her, we would certainly, I anticipate, take a forceful approach to any public law challenge. Yeah. But I accept that the tribunal doesn't deal with it. It seems to proceed on the basis that actually for an appellant the KV approach is better, and that's the way that I read that paragraph.
Yes. I mean, that's certainly how I read it. It's along the lines of, well, I've looked at all the evidence myself.
Yes.
And,
you couldn't fare any better.
Yes.
Certainly, if you don't succeed with me looking at all the evidence, that does seem to be what's being said. But I accept it's not express.
All right, that's really helpful. Thank you very much, Ms. Smythe.
Thank you, my lady.
Yes, Mr. Malik.
Just dealing with the Begum issue first. Moylan friend quite properly and fairly accepts first that there was a public law challenge before the Upper Tribunal. Secondly, the Upper Tribunal has not dealt with that public law challenge. And third, the public law challenge is not hopeless. That, in my respectful submission, means that this appeal should succeed if the court were to conclude that Begum applies and Shimi was correctly decided.
Before Mr. Malik gets into his flow, could I just show him something in his skeleton argument which is helpful to him?
Yes, so this is a skeleton argument that is not in the bundle. I do not propose to hand it up because it's common ground that there was a proper public law challenge before the Upper Tribunal.
Right, so that's paragraph 14 of the Upper Tribunal skeleton, is that right?
Yes.
Okay, that's right.
Not the skeleton that you have
in the bundle,
but a different skeleton that the Upper Tribunal invited specifically on that point.
It doesn't say very much, but it certainly says there's a public law challenge.
Okay.
You asked a question as to whether one
I think
can
it
use...
might be helpful if we could be sent that, please.
I think it was, if it's being advanced as it is, I think yes. Could we have the whole skeleton?
I have spare copies.
But could we have them now? And it's 14.
Yes. Thank you. this was the sort of summary of the public law ground, which was then developed orally before the Upper Tribunal. The Upper Tribunal summarised the argument at paragraph 29 of its decision that I've shown before.
Sorry, so A, 14A, is effectively the same challenge in a sense, isn't it? As it was not based on the evidence.
Yes. If my Lord wishes to see how the case was put to the Upper Tribunal, the public law challenge was put to the Upper Tribunal, then the best place to look at it is the Upper Tribunal's decision itself, paragraph 29.
Okay. Yes, thank you.
So there was a question as to whether Article 8 can be used to circumvent Begum, and I think Moylan friend suggested that it could, because if Article 8 is in play, then one would make the judicial fact finder would make the relevant findings of fact. If that is the case, then one wonders what was the point having the argument yesterday. I mean, if one can use Article 8 to persuade the tribunal to make findings of fact, then all this debate is entirely academic.
Well, that was one of the questions, as you would have seen from watching yesterday. We raised whether it really made any difference, and Chimi makes it clear that Article 8 is still in play.
But there is one point that was made in Chimi that is at paragraph 3 of the head note. So in Chimi, the presidential panel said that, well, when you make findings of fact in Article 8, the tribunal is not allowed to say anything on the issue of precedent fact. So you can't go to that territory at all. So it's tab 34 of the authorities bundle.
Paragraph 8, you say?
Sorry, paragraph 3
All right, thank you.
of the head note. In considering question C, this is human rights, the tribunal may consider evidence which was not before the Secretary of State, but when doing so, it may not revisit the conclusions it reached in respect of questions 1A and B, which is the question of deception and precedent fact.
Yeah.
So what is being said is that, well, the tribunal can receive evidence about the strength of family life, for example, or strength of private life, but Article 8 claim must be decided on the basis that there was deception.
Yes, so in other words, on the basis of the facts as found by the Secretary of State, and then there's a balance between the public interest on the basis of the Secretary of State's findings of fact and the Article 8 right of the appellant.
Yes. Now, whether that is right or wrong, that's another question. But that's how Chimi is being treated.
Okay.
But if this court approves Chimi and says that it's correctly decided, then this appeal should succeed, because if you look at paragraph 2 of the judicial head note, the tribunal must only consider evidence which was before the Secretary of State.
Well, what Ms. Smythe said was, yes, look at that, and you had two inconsistent statements, one of which said, we were divorced, I'm very happy with my new partner, and the other of which says, actually, we never split up, and therefore the material facts, even if you were applying the Begum approach, then you would fail.
This appellant failed in the Upper Tribunal for a number of different reasons. The first reason was the inconsistency in the evidence that was given at the Upper Tribunal.
Absolutely, the brothers and the appellant.
Yes. So on Chimi, the tribunal should not have taken that evidence, should not have heard that evidence at all, should not have taken that into account at all.
Would we be entitled to take that into, go back to what was before the Secretary of State and then say, this is I mean, in the same way that we would have a discretion about whether to grant permission to apply or decide whether to quash a decision and say it's inevitable, the decision would be the same.
Not in this case, I say with respect, because this question was put to my learned friend by my lady, and my learned friend said that, well, the challenge is weak, but she did not say that the outcome is inevitable. It is not her submission that the case is so hopeless that there is only one potential outcome. That's not the submission that she made. So in my submission, it wouldn't be appropriate in this case to dismiss the appeal on that basis.
So could I just explain our position, which is that if the 3 grounds are dismissed, I say that's the end of it. It doesn't then go back to the tribunal. In other words, my learned friend can't use Begum as a sword. I say what happens if his 3 grounds are dismissed? Then that's the end of his appeal. To be clear.
Well,
And what do you want to say to Ms. Smythe's point on that, which is, if your 3 grounds, I mean, obviously we've got to work out what we think of them.
yeah.
But if they didn't succeed, does Begum arise in this appeal?
Yes, and I say that it does. I mean, either my learned friend is right or she is wrong. Either it's really a jurisdictional question. Either Begum applies or it's not. My learned friend says that, well, if you dismiss the appeal, that was her submission. If you dismiss the appeal, then Begum issue does not arise. But in order to decide whether to allow or dismiss the appeal, in my submission, the court must decide whether Begum applies or not. Because if Begum applies, then my 3 grounds are academic, because they are challenged to the findings of fact. And then the real ground is the 4th ground. But if Begum does not apply, then my first 3 grounds are live grounds, and this is how I respectfully invite the court to approach the appeal.
And what about, just so that we can note your answer to this, what about the proposition, well, you asked for a factual hearing, you brought challenges to the factual hearing, and find in another case we might have to confront, does Begum apply, but actually we're just dealing with this particular case and whether this is a fair outcome.
In this case, yes, the appellant did ask the tribunal to decide the issue as an issue of fact, but he also expressly raised a separate public law challenge that was raised at the Upper Tribunal expressly and also at the First Tier Tribunal.
But that was an alternative if your primary case, that it had to be decided by a reconsideration, was rejected. So it wasn't, we're advancing both cases. The case that was being advanced on behalf of the appellant was, you, the tribunal, must hear the evidence, make the decision for yourself. If you're not going to do that, then we make these public law challenges.
Yes.
It was an alternative.
It was. I entirely accept that. But at this court, in my submission, the Begum issue goes to the jurisdiction of the tribunal, whether the tribunal had jurisdiction to adjudicate on this fact. And this is the question that, in my submission, the court must decide in order to decide whether to allow or dismiss the appeal. If the court concludes that the Upper Tribunal had no jurisdiction, as my learned friend submitted yesterday, to adjudicate on the issue of fact, then that necessarily means that our public law challenge is live and should go back to the Upper Tribunal. Dealing very briefly with the other points that my learned friend made, so my lords and my lady will recall that my learned friend took you to the decision in Rahman. This is behind tab 5 of the green bundle that dealt with the directive, and she took you to paragraphs 22, 23, and 24.
Yes.
And I think the point that she was emphasizing was that there is the directive, but then there is a wide discretion on each member state as to how, what factors to consider. This is paragraph 24. But you'll see a reference to the national legislation, national legislation at paragraph 24 and 25. So there is the directive. The state has, entirely accept, a wide discretion as to the selection of relevant factors. But then the court made it clear that, well, that's got to be in the national legislation. So the legislation must set out the criteria. Now the legislation in the instance case, in this case, is not the policy. The legislation that to give effect to the directive are the regulations. And if one looks at the regulations behind tab 3, I asked my lords and my lady to look at the definition of the durable partner that was highlighted when I was making submissions. This is page 18 of the bundle. And then consider whether, on the facts found, whether the appellant was in a durable relationship with the EEA national. If the appellant met this definition, and if he was in a durable relationship, then grant of residence card was entirely proper. There is nothing in that definition that excludes a partner who is married to a different individual outside the United Kingdom. So my learned friend in my submission effectively asks you, my lords and lady, to delete the words present in the United Kingdom. There is, in my respective submission, no justification for that approach. So my learned friend then took you to the relevant parts of the guidance and showed that the guidance demonstrated that the other relationship or marriage must have come to an end, and you have my submission that guidance is not national legislation. This is the legislation, and on any view, the appellant met this requirement. But if you look behind tab 1 of the same bundle, the green bundle, if you look at page 4, you'll see the Secretary of State's guidance. This is the guidance that was before the Upper Tribunal, that the Secretary of State provided to the Upper Tribunal. I'm not sure if other guidance documents were before the tribunal, but this guidance was. And if you look at page 6 of the bundle, you'll see a heading durable partners, and this is quite similar to the guidance that my learned friend showed you. But my learned friend, when a question was put to my learned friend as to what would have been the outcome of the application if the appellant had disclosed the relationship with Mrs. Sabuhi, she said, well, the application would have been refused, and she referred to the criteria that you have in 4 bullet points at paragraph 6. And the 4th bullet point is that any marriage or similar relationship by either party has permanently broken down. But if you look at the sentence just above the 4 bullet points, you'll see that this isn't a strict criteria. It says the following condition should normally be satisfied. And if you then look at paragraph 8 and see how that paragraph ends, this is the Secretary of State's own guidance. Each case must be considered on its merits, taking into account all facts and circumstances. And there may be cases where the applicant has not satisfied all of the above criteria, but the caseworker is satisfied that they are in a durable relationship. So this isn't a set of mandatory factors that the Secretary of State has enacted through legislation. This is a fairly flexible policy document which acknowledges that even where the previous marriage has not permanently broken down, there can be a durable relationship. And given that there is no dispute between the parties that the appellant's relationship with Ms. Sabuhi was durable, in my respectful submission, the Upper Tribunal was wrong in proceeding on the basis that if the the existence of relationship with Mrs. Subuhi had been disclosed, the application would have failed. Now, Moylan took you to.
Do you want to say anything about the Zurich Insurance Authority?
Yes. That was on my list.
Oh right, I'm so sorry. I don't want to interrupt you or take you out of turn. So just I mean when it's convenient.
Yes. Yes, I thought it would just help the code if I take the points in the same order.
Yes, of course. No, absolutely.
So Moylan next, after taking you to the guidance, took you to the entry clearance application, identified certain inconsistencies, demonstrated how the case changed, and why the Upper Tribunal was not impressed with the evidence and the account. Now, those are all valid points, and I advance no criticism as to the Upper Tribunal's analysis of the account generally, and the way in which the Upper Tribunal identified the discrepancies. My submission is that if you look at paragraph 60 of the Upper Tribunal's decision, it's page 51 of the bundle, Moylan is absolutely right that there were different threads in the Upper Tribunal's reasoning. But at paragraph 60, this is the conclusion. The Upper Tribunal says that, well, I'm making this decision, drawing all these threads together. So it's not the case with respect that the Upper Tribunal dismissed the appeal simply on the basis of discrepancies. The Upper Tribunal looked at all the circumstances, all the threads, and then dismissed the appeal. And if I'm able to persuade the court that one of those threads was defective, and the Upper Tribunal was not entitled to take that into account, then in my submission, that means that the ultimate conclusion is unsustainable. So the fact that I've not challenged other threads of the analysis does not mean that my challenge fails. Moylan then took you to KA and SM. In KA, Moylan has not taken you to any finding of fact by the tribunal that sexual intercourse in Pakistan is illegal except between husband and wife. She hasn't taken you to any finding. This tribunal, our tribunal, said that in KA, the Upper Tribunal noted that sexual intercourse is illegal. That, given that Moylan hasn't taken you to any finding to that effect, that comment by the Upper Tribunal in this case, in my submission, is not justified. The Upper Tribunal isn't saying that, well, there was evidence of Dr. Shah before the Upper Tribunal in 2010 that suggested that sexual intercourse is illegal. If the Upper Tribunal had said so at any stage, then one would have expected the appellant to have dealt with the issue, and as I pointed out earlier, considered adducing some evidence on that. Moylan then took you to SM. She made a general submission that women are treated differently in Pakistan, but she hasn't taken you to any finding that says that they are treated as chattels. This is what the judge in this case said. There's no answer to the other point that I made, that SM is all about lone women. So everything that the Upper Tribunal said in SM was about the position of a lone woman who is residing alone with no support from the family. But this individual, Mrs. Subuhi, wasn't a lone woman. She was married, she had children, and lived with the family. The reliance on SM in my submission is equally flawed. Moylan said on instructions that, well, country guidance given in relation to Pakistan applies with equal force to Kashmir. But there is no evidential basis for that submission. Moylan friend hasn't taken you to any part of the country guidance decision that suggests that it also applies to Kashmir, to the autonomous region of Kashmir. And the Upper Tribunal has not explained why it was applying the country guidance in SM and KA that related to Pakistan, in particular to 4 provinces, to someone who resided in Kashmir region. So next, Moylan friend took you to tab 38. This is the Zurich case. Moylan friend asked you to consider paragraphs 30 and 39. I think what Moylan friend was seeking to submit was that the appellant cannot deny materiality of the fraud if there was fraud, and this is the point that was made. Now, can I take you respectfully to tab 46 of the authorities bundle in reply. So this is chapter 55 of the Secretary of State's guidance. Starts at page 1125.
Yes.
Chapter 55, if you look at paragraph 55.7, that deals with materiality. Page 1130.
Yes.
Paragraph 55.7.3, if the fraud, false representation, or concealment of material fact did not have any direct bearing on the ground of citizenship, it would not be appropriate to pursue deprivation action. And this entire section deals with materiality. So the Secretary of State's own policy, and this is consistent with the case law, is that she would deprive a person of citizenship if there was material fraud, if there was material concealment, something that had a direct bearing on the ground of citizenship. So Zurich, with respect, is a case that concerns an entirely different context. And the submission that Moylan friend makes with respect is irreconcilable with the Secretary of State's published.
Yeah, I think what Zurich was being relied on, perhaps impermissibly or not, was to say that if you're actually making findings of fact and someone says it's immaterial, you're right, it has to be immaterial, and that makes it clear. It doesn't really lie in their mouths to say, well, I told this massive lie to obtain something, but actually it turned out to be immaterial. I mean, I don't think Zurich takes it any further than that.
No. But if the submission was that, yes, if the submission was that this appellant cannot make a materiality point.
Well, of course you can, and all that the Secretary of State is saying is that, well, you know, why did you put it in the first place?
Yes.
But you're quite right, if it is immaterial, that is a good point.
Moylan friend then dealt with IV and said that it does not apply, there shouldn't be any gloss on the statutory language. But what she hasn't explained with respect is how that is consistent with paragraph 55.7.7 of the document that we are looking at. I took you to that earlier in my submission. Secretary made it absolutely clear that the false representation or fraud or non-disclosure should be deliberate, should be dishonest. Moylan friend submitted that, well, whatever the case may be, the Upper Tribunal has found that the appellant was dishonest. Now, the Upper Tribunal has found that the appellant was dishonest in relation to the EEA application. And the Upper Tribunal then said that there was non-disclosure. This is paragraph 68 of the judge's decision. The judge said that, well, the previous application would have been refused. There was past dishonest conduct. but then said that the citizenship was obtained by concealment of material facts. So when I say that there isn't a finding of dishonesty by the judge, in this case I say that there is no finding of dishonesty in relation to the citizenship application. The question is whether the citizenship was obtained by fraud. What was the appellant's state of mind when he was completing his citizenship application form? The Upper Tribunal did not say, made no finding as to whether concealment was deliberate. Concealment in the application, in the nationality application, was deliberate or dishonest.
I think the point that's being made is you wouldn't have got there at all but for the acquisition of residence card and the permanent residence card. So by means of
yes,
can include by means of during the course of the process.
Yes. So two obviously in my submission, two different points. You have my submissions on,
yes,
on the first point.
I think I keep asking the same question. Yes.
Just one final point, and that's really an admission that I got something wrong in my opening submission. So the first question that you asked me whether it's appropriate to refer to Mrs. Sabuhi as the appellant's wife, and I gave an answer which wasn't very helpful, and then I said no. Question was clear. I misunderstood it. I apologize. It is entirely appropriate to refer to Mrs. Sabuhi as the appellant's wife. What I had in mind and what I was seeking to say was that the appellant's position is that he did not consider Mrs. Sabuhi to be his wife between 2008 and 2017, but he is his wife as of the date of this hearing.
Thank you.
Very good.
No, thank you very much. Thank you all very much for your submissions. We are going to reserve our judgments. They will be provided to you in draft in the usual way for typographical only corrections, and you know the prohibition on any other use. And we would hope that once you receive the judgments, you'll be able to agree a draft order, but if not, we will deal with any outstanding issues on paper. So that brings this hearing to a conclusion. Thank you.
All right. Lovely to see you.
Yeah, good to see you. It's just that you do not avoid